Yes, Ms. Perry. I can tell you before you begin that we have read the judge's order. We have read the judicial review claim form, the facts and grounds, the summary grounds of resistance, and the skeleton arguments. I'm not aware that we have a skeleton argument from you for the appeal, but we have your skeleton argument below.
My Lord, you haven't got a skeleton argument. We're relying on the skeleton argument that was drafted for the before it came through, Mr. Justice. No, I know. I think your Lordship said you've read the grounds of appeal.
Yes.
Exactly. My junior was just reminding me, and I thought I hadn't misheard. My Lord, my Lords, my Lady, I appear, as your Lordships know, and my Lady knows, for the claimants, together with Mr. Francis Hoare, my learned friend. Mr. Ewan West appears with Ms. Catherine Dobson and Ms. Ruth Keating for the Secretary of State. My Lord, there are a number of issues that this court is going to be asked to address, and I'm actually going to ask the court to bear with me because I'm going to take them in a perhaps slightly odd order. Your Lordships are going to have to consider the issue of whether actually you should be allowing permission at all, pursuant to the CPR raised by my learned friend, the issues of the timings, the claim, and other what I can call technical matters. I will not avoid addressing those, but I want immediately to get into the heart of what this appeal is about, which is the urgency of the injunction in respect to this cohort of children.
Just by way of bullet points, under your heading technical matters, what are they?
Well, I think what I'm calling technical matters are things like the Practice Direction 5246.
Oh, I see.
And the question of my learned friend's points on the whether or not we're out of time on the issue of judicial review with respect to the authorisation, certainly for 16, 17-year-olds. That's what I call the technical matters, my Lord. But, my Lord, there are obviously other headings which I will come to, and in a moment, obviously, I will do that under balance of convenience, for example, the American Sign principles. That will be another area of heading, and obviously there will be the heading of urgency. My Lord, the first issue, however, that I'm going to tackle is essentially one of the Siam principles, which is that this is a serious case to be tried. It's very serious. In that, the court is being asked to issue an injunction in respect of vaccines for a cohort of youngsters which are being rolled out as we speak. What our case essentially is that the primacy of any decision by the Secretary of State has to be the welfare of this cohort of children. It runs through all our courts, from the Children Act and before the Children Act, and any case involving children must take the child or the youngster as the primary concern. And in this case, when it's the question of administration of a medical procedure, it is particularly important because we're talking about an intrusive procedure where the recipient, we say, is at risks which have been recognised by the government, by the Secretary of State, by the committees variously advising, but are not being sufficiently disseminated or at all in order for either the children who are competent or their parents to make an informed decision.
Sorry, so your point is that the known risks have not been sufficiently disseminated?
Correct. And, my Lord, I'm going to take your Lordship to the very documents that emanate from the defendant to demonstrate exactly that point.
So would it follow then that if the known risks are sufficiently disseminated, there will be no warrant for any interim relief?
No, because our case goes further than that. That point that I've just made answers the issue of, oh, but the vaccines are not mandated. They are vaccines that you can refuse. They're voluntary. My lord, my answer to that is every medicine's voluntary. There is no such thing as a mandated clinical procedure. But the question arises as to whether the procedure should be carried out at all. And in this case, what we say, my lord, is that the risks are such that they do not warrant the vaccination of this cohort of children, and the government knows it because it's in their own documents. And the arguments that they've used to encourage the vaccination, I am proposing to show the court do not hold water.
But so far as your clients are concerned,
yes,
they can refuse.
Well, my clients can refuse, but my lord, my clients have standing to bring the matter, and your lordships have equally jurisdiction to consider whether, if the decision by the Secretary of State as regards my client is irrational, then it must be irrational in relation to the entire cohort of.
Well, I follow that, but what we are concerned with is a period of approximately 7 days between now and the date that's fixed for hearing your application for permission for judicial review and your application for interim relief. So the question for us is this really so urgent that the vaccination programme should be immediately suspended at a time when the Secretary of State has not yet had an opportunity to put in any evidence?
Well, my lord,
that's what we have to decide.
I certainly understand that, my lord. What I'm proposing to seek to address the court on and persuade the court is that we are relying on, by and large, the evidence that is available to the Secretary of State.
Yeah.
It is the Secretary of State's own evidence. And therefore, if there is other data or other evidence, we've been asking for it for a very long time and it's not been forthcoming. And we know from the contents of the documents from the Chief Medical Officer as well as from the Secretary of State that there is nothing else, because we know what has been referred to for the purposes of making this decision. And it's that, we say, that creates the irrationality, because if the data that I'm going to put before your lordship and your ladyship is the government's own data and can show that it just simply doesn't stack up to a rational decision, it follows that the government can say, well, we need more time, but the answer to that is to do what?
Staying with my lord's point, would you accept that the risk to the two claimants, children who you represent, between now and next week is in fact zero?
Is in fact
zero. They're not going to.
They're not
going to be vaccinated during that time. It's their perfect right
no, my lord,
not to be vaccinated.
I can't resolve from that and say that it's not, unless, of course, and there is one small unless, one knows that peer pressure does operate.
Yes, but as in the current circumstances, the likelihood of peer pressure operating to change that position can be effectively discounted, can it not?
It is very unlikely, my lord. I certainly agree with that. And I agree that your lordship's point is absolutely right, but of course, as your lordship...
So the application is not being pressed for effectively emergency interim relief on any basis related to these two children?
Well, my lord, save and insofar as these two children represent and are entitled to represent...
Well, you say that they take upon themselves the mantle of all children. But the effect of your application succeeding might be that many children who want to have immunisations over the period of the emergency relief won't get them.
My lord, yes. Equally, of course, the effect of your lordship's refusing would be that many, many children may get the vaccination, and there may be many, many potential problems arising out
Yes,
of it.
but I ask you this because it illustrates the difficulties in two particular children seeking to take upon themselves the mantle of all children.
My lord, my understanding with judicial review claims, and I have to confess this is not a court that I'm totally familiar with on this procedure, is that it is not unusual for a selection of persons with standing to challenge a decision which will in fact impact on many others.
Well, that's not an issue. Your clients undoubtedly have standing
Yes.
to challenge the decision. The question is, as my lord puts it, is emergency relief warranted?
Yes. Well, that's a matter for your lordship, your lordships and ladyship to consider as to whether you think on the evidence, and I submit it is there, that this is so irrational a decision to be rolling out this vaccine to this group of children, of whom my clients represent too, that in fact it is more unsafe to allow the rollout to continue than to stop it. But more to the point, I am going to take you to evidence that demonstrates that since this cohort of children are in no danger whatsoever, and the only thing this court should be considering is the health and safety of children, that therefore all that is being interrupted is the government mechanisms that are in place. And the question is whether government mechanisms trump health and safety. And my submission is they do not. And the court, on looking at the evidence, may well take the view that it is at the narrow point that my two clients aren't going to be affected and therefore no injunctive relief is warranted, or the court may take the view that the evidence is sufficiently concerning that actually a pause should be placed on this rollout from today rather than considering it from next week. But I completely understand the hurdle that has been put in front of me, and the only way I can seek to climb that hurdle is to generally take the court to what we say demonstrates the true position as far as this vaccine is concerned, and that the entire decision is irrational based on the government's own advice and documents. So I wonder if I could start.
Yes.
If your lordships start, I'm going to start with actually a document which is to be found in Bundle 1 at page 308. Your lordships done that. It's
Yes.
If my lord looks at, or your lordships look at paragraph 5, where
5?
first, yes, on page 308, you will in fact find.
Sorry, which is 5? Make provision for wholesale dealing of. Is this page
No,
313?
a temporary authorisation starts.
Well, 308.
Yes. It's under.
Starting, COVID-19 is the biggest threat this country has faced in peacetime history. Is that the document I
That's
suppose?
right.
Right.
That's right.
Paragraph 5,
Yes.
numbered paragraph. Oh, I see.
No, they're not. I'm sorry, you have to count them down.
Policy
I apologise.
objectives. Is that?
It says a temporary authorisation. That's the it's the paragraph that starts a temporary authorisation.
Oh, I see. I thought we were talking about numbered paragraphs.
No, I'm sorry. None of this.
Right.
None of it. There aren't any number
Yes.
paragraphs in there. What it in fact refers to there. And if we go to the section of that which talks of, you'll probably see about halfway down, the licensing authority, and in this case the licensing authority of course is the MHRA, may consider that the balance of risk and benefit to patients justifies the temporary supply of the relevant vaccine.
Yes.
And then we move to, sorry, I should have taken you 3 lines above that. Forgive me. It's the sentence that starts, a COVID-19 vaccine would only be authorised in this way if the UK's licensing authority was satisfied that there is sufficient evidence to demonstrate the safety, quality and efficacy of the vaccine. And that is the guiding position, safety, quality and efficacy. We see that repeated, and I don't need to waste the court's time, but we see that repeated over and over again. And the only point I would take you to is at 310. Again, I'm sorry, it's not numbered, but it's under the section proposed amendments in relation to temporary authorisation. And you'll see the paragraph that starts, sufficient evidence of safety, quality and efficacy is also, of course, the standard by which marketing authorisation applications are judged. So that is the starting point, that we are looking at the recognition by the government, safety, efficacy and quality. And indeed that very same phrase was used on the 3rd of June by the, not surprisingly, the head of the MHRA, when, if my lord looks at, I think it's bundle 5 at page 56, which is the Peel bundle. I'm terribly sorry, I should do this with tabs, but I'm stuck on
5, page 56.
Tab 6.
Sorry, it's tab 6. Yeah, I apologise.
Well, that's just got a date on it. It's
Yeah,
part
no,
of
no, quite right.
Mr. West's skeleton argument.
I've managed, of course, to get the, I've managed, of course, to get the, no, that's, yeah, I'm looking at the wrong, I'm looking at where Rain says what she does. Do forgive me, my lord, I've managed to put the wrong reference in my note, which is very typical, of course. It's the yeah. Yeah, I think it's bundle 4, it's supplementary bundle.
Sorry?
Bundle 4, my lord, yeah.
Bundle 4, right.
So in which case it's tab 10. Tab 10, Lords and Ladies.
Tab 10, yes.
Yeah.
Of the,
Bundle
Impact on school absence.
Oh, no, that's absolutely.
no, it's not tab 10, I'm sorry, we're totally, it's the core bundle that we need. How did I get this totally muddled up? So much material.
But what's the point you're making?
The point
Mr.
I'm
Berry?
making, my
That
lord,
that safety, quality and efficacy is repeated in what the MHRA says.
But she also said,
Yeah.
on the 3rd of June,
Right.
and this is the point, that there was a finding, and this is what I wanted to get to, that on the 3rd of June, they had formed the view that the benefits outweighed the risks, and that nevertheless it would go to the Joint Committee of Vaccination and Immunisations. But the question really on the 3rd of June,
My Lords and Ladies, I'm sorry, it's bundle 2, page 56. That's
Bundle
that's,
two.
That's where I
the
went
documents bundle in the
Sorry.
original judicial review and the MHRA announcement, which has quotations from Dr. June Ray.
Let's go to that. I'm so sorry, I had bundle wrong. That's where I page right, bundle wrong. I do apologise, Marie.
Yes.
What Dr. June Rain said. We've carefully reviewed the clinical trial data in children aged 12 to 15 and have concluded, this is on the 3rd of June, that the Pfizer-BioNTech COVID-19 vaccine is safe and effective in this age group and the benefits of the vaccine outweigh any risk. And although she said no extension would be approved until the expected standards of safety, quality and effectiveness have been met, the problem with that statement, I say to this court, is that that was both disingenuous and wrong. Because on the 3rd of June, Dr. Rain had no basis for saying that there was a conclusion that the vaccine was safe and effective in 12 to 15-year-olds. And one can know this because I'm now going to take your lordships to other government documents, namely the government documents that were produced by the Joint Committee of Vaccinations and Immunisations, which of course is the statutory body charged with considering safety. And if I can take your lordships now to each of those documents, they are to be found
Bundle 2.
in bundle 2, which is the documents
Tab
bundle.
7.
Thank you. The first one is at tab 7, which is 15th of July at page 134. And you will know from the skeleton argument, or perhaps not because it's in the original skeleton argument, that this document has been quoted by us in our skeleton in respect of the original injunctive relief.
Yes.
But at page 136, you will see that the Joint Committee on Vaccination and Immunisation actually says in terms, any decision on deployment, this is at page 136, any decision on deployment of vaccines must be made on the basis that the benefits outweigh the risks to those who are vaccinated, statement of the obvious. But then we move to page 138. And at 138, we find the following. This again, I repeat, is the government document advising the government and the MHRA. And please bear in mind that this is being written just about a month or so after Dr. June Rain has said we've concluded the benefits outweigh the risks and it's safe and effective. Less than 5 weeks later, the JCVI says they have carefully examined the risk of COVID-19 to children and young people. The evidence strongly indicates that almost all children and young people are at very low risk from COVID-19. Where symptoms are seen in children and young people, they are typically mild and little different from other mild respiratory viral infections which circulate each year. The incidence of severe outcomes in children and young people is extremely low. In England, between February 2020 and March 2021 inclusive, fewer than 30 persons aged less than 18 died because of COVID-19, corresponding to a mortality rate of 2 deaths per million. During the second wave of the pandemic in the UK, the hospitalisation rate in children and young people was 100 to 400 per million, but most of those hospitalised had severe underlying health conditions. So much for the benefits. Now we look and see what the JCVI says about the risks. For children and young people without underlying health conditions that put them at high risk of severe outcomes from COVID-19, the direct individual health benefits of COVID-19 vaccination are limited. And it goes on to the end of that paragraph that currently less data are available on the safety of COVID-19 vaccines in children and young people compared to adults, and the JCVI carefully considered reports of myocarditis following the use of the Pfizer-BioNTech and Moderna vaccines in younger adults. At this time, JCVI does not consider the benefits of vaccination outweigh the potential risks until more safety data has accrued and their significance for children and young person has been more thoroughly evaluated. A precautionary approach is preferred. And then they go on to talk about even the problem of the PIMS-TS, the Pediatric Inflammatory Multisystem Syndrome, that again, the underlying cause is not properly understood. It's not known how the COVID-19 vaccination might influence the occurrence of severity of PIMS. And we then go to the next section where even so far as so-called long COVID is concerned, the JCVI says that the risk is very low in children, especially in comparison with adults. Indirect health benefits, modelling from University of Warwick and Public Health England indicates vaccinating children and young people could have some impact on hospitalisations and deaths. However, the extent of such benefits are highly uncertain. Now, this is the point of reading this, Lord, is that looking at that document relative to what Dr. June Rain said on the 3rd of June, which was, we have concluded that the benefits outweigh the risks. And the question one asks then is, on what basis are these statements being made when their own statutory bodies are actually investigating and coming out with something that couldn't be further from what Dr. Rain is actually
Is it as stark as that? The MHRA are saying you can use this vaccine in over 12s. The JCVI is addressing a different question, which is should you? And they say, yes, you should, for those children who have underlying health conditions.
Yes.
If the MHRA had said you can't use it, then it wouldn't be capable of being used at all.
That's not correct.
Is it not?
That is not correct. That is exactly the point that is made in certainly either our grounds or our skeleton. In fact, my Lord, there is provision under the MHRA that was especially provided for, whereby you can use unauthorised medicines if a clinician considers there's a clinical need. And that is exactly the basis upon which we put the case, that therefore those in clinical need are not excluded from the use of the vaccine. That is a very important inroad into this, and it therefore would not deprive
you can administer an unauthorised and unlicensed medicament if a clinician thinks it's suitable.
Well, it's been set forth by statute, by regulation. Yes,
amendments to regulation.
On a separate point, I noted you to describe the MHRA statement at the beginning of June as disingenuous. Is it really necessary or indeed appropriate to use that sort of language?
I will withdraw the language. I will put it this way, my Lord. There is a dissonance, if you like, between what's
yes,
been said.
They're saying different things from different perspectives. I follow that.
My Lord, it's troubling that somebody who is in an important position of influence as the head of the MHRA is making a bold statement that she is satisfied in respect of the efficacy and safety of a vaccine. It isn't a question, if she'd have simply said, we consider that it's entirely appropriate to authorise it, but we are waiting for more data and recommendations from the Joint Committee. My Lord, I would have absolutely nothing to say about that. My criticism, and I do maintain it as criticism of this, is the unvarnished confidence with which Dr. Rain says, as she does, we are satisfied that the benefits outweigh the risks. And my question then is, on what basis were you satisfied?
Well, she explained. She says we've carefully reviewed clinical trial data.
Well, but it was for the joint vaccination, the Joint Committee on Vaccination and Immunisations to be doing exactly that. She must have known that that exercise was in fact underway.
But you have to look at what's said on the following page, on page 57, don't you? The Chair of the Commission on Human Medicine says that there's been a thorough assessment and review of the data looked at by the Paediatric Medicines Expert Advisory Group, who are scientific experts within this age group. The MHRA will continue to scrutinise all the suspected side effects data through a surveillance programme. So it's not just a bald statement. I mean, the basis is being explained. There's been some expert input from two different groups. They're going to continue looking at it, looking at studying side effects.
Well, if the court considers that it's not giving a misleading impression to the public generally at large to actually describe a vaccine as safe and effective in this age group and the benefits outweigh the risk, then that is obviously a matter of the court. It is our submission that...
But your point was that this decision was irrational.
Yes. And it's irrational against what is, in fact, was then known and is known now, and has become more and more apparent in terms of the safety and efficacy of this vaccine. There is a very confident assertion on the part of the government and government departments about the safety of this vaccine, which is not, frankly, shared by their own statutory body, the Joint Committee, which, after all, is charged with looking and advising on safety and on rollout. And of course, it's not just the Joint Committee. There's other evidence that is before, or should be before, those making the decisions. But I wonder if I could just take you, please, to the second.
Tab 8.
You want the 4th of August
It's
one?
in the documents bundle to
Tab 8.
tab 8. Thank you.
Exactly.
Yeah.
This is the 4th of August one, yes?
Yeah, that's the one. Sorry.
Yeah.
We go to tab 8 and under tab 8. This is the...
And you really want the section starting benefits of vaccination,
We do.
wider health implications and operational considerations, and then current advice.
And if your lordship has got that, you will see that it's equally. This, of course, is the condition. This is the report that considered that the 16, 17-year-olds could be vaccinated, but still held out that the 12 to 15-year-olds should be held back. And the slight concern here, of course, is that I ought to also now take you to another document that was around about this time. There's discussion here about existing offer of 2 doses, 16 to 17-year-olds, who are in the at-risk group. But we now know, of course, that in fact, there has now been suggestion of only 1 dose. And what I want to take your lordships to is a document that was issued again in June, mid-June, by the WHO, World Health Organization.
Yeah.
Which is, sorry to be jumping around here, but the WHO document is to be found at I do need to find. Gosh, on the other document. Yes. Okay. Sorry.
It's in supplementary bundle 116.
Yes, 116. Thank you. I just found it. Supplementary bundle. So it's bundle 4, page 116.
Page 116.
116, yes, please. And if your chips could go to page 124. This is a document, by the way, that was dated, or is dated, the 14th of January, first issue, 2021, updated on the 15th of June.
Yeah.
And
Page 144, yeah.
124, you see in the box under conclusion, we have low quality,
Sorry,
low confidence.
what page am I looking at?
Sorry, 124.
124, sorry.
124, yes. And your lordships will see we have low confidence in the quality of evidence that the risk of serious adverse events in children following 1 or 2 doses of vaccine is low. There's lots of negatives there, but I think your lordships can follow what's being said. In other words, we are concerned that the risk of adverse events, quality of evidence, shows that the risk of adverse events is low. So it could be high, could be medium, we don't know. But one thing that is clear is that this document, which is from, as I said, the WHO, tells us at page 155 that all the statistics are based on sorry, that's not at 155. They're based on 2 vaccines, but at 155, which I want to take you to, where it says balance between benefits and harms, under the column unclear is crossed.
Yeah.
Based on limited safety data, the balance of benefits and harms is highly context specific and remains unclear to date. So that was further data out there. And again, what we have been at pains to try to obtain from the government before we go to the September JCVI document, is, well, what data were they looking at? Because this is all official data coming from the government's own documents, and if they were looking at something else, we've got World Health Authority organisation data, we've got the Joint Committee on Vaccinations, who are obviously looking at data. So the point is that even in September, and despite the attempt by the MHRA and indeed the Chief Medical Officer to suggest that the Joint Committee had now fallen in line and was now actually advising for vaccination for the 12 to 15 cohort. In fact, that's not correct. And I'm going to ask your lordships to, and it's now, this will be in
I don't think it is suggested that that's what the JCVI did. JCVI said the benefits of vaccination 12 to 15-year-olds marginally outweigh the risks. We don't think that margin is sufficient to be able to We recommend vaccinating 12
Yes.
to 15-year-olds, but
Yes.
we advise the Secretary of State to take advice from the Chief Medical Officer,
Right.
and that's what he did.
Well, first of all, there's two issues that arise out of that. First of all, whether the Joint Committee was entitled to even do that, to delegate that to the Chief Medical Officer, because under the statute, it is the Joint Committee and it is the Secretary of State who accepted that he'd take the recommendation from the Joint Committee, not the Chief Medical Officer. The Secretary of State made it very clear.
But the JCVI were saying that things like educational benefits were things that they couldn't consider, and that was appropriate material for the Chief Medical Officers to consider.
Well,
What's wrong with that?
That's my second point, my lady. There's everything wrong with that, because the issue of education is a policy issue, not a clinical health issue.
Precisely.
And it's something, yes, but it's something that is in the government control simply on the basis that.
But,
can I just take this?
But
as
also,
an overarching-
when the CMOs dealt with the question of education, they were concerned about the health effects on children of disruptive education. So they weren't advising on the broader policy issue; they were advising on the health effects.
That is a way of, if I may respectfully say, glossing the position in one respect, because the problem is that if you want a particular result, namely to say, it's like putting up a straw man and then knocking it down. We will create the disruption to education, and in order to stop that disruption, we will say vaccination is the way to go. But behind it, and I still come back to this point, behind it has to be what is in the best clinical interests of the children, and is it necessary? Because one problem, and I'm going to take you to this, one major problem of the way the CMO, the Chief Medical Officer, constructed his report, or a number of problems, is he did not take into account the fact that a very large percentage of children would have already had COVID-19, symptomless or otherwise, and therefore have immunity. That was not taken into account.
Can I just break down your proposition?
Yeah.
You say that what is important is the clinical interests of the children.
Yes.
Now, that, I suggest, is a narrower criterion than the welfare of children. Do you agree?
Welfare, of course, covers a great deal in certain contexts.
Yeah, because you started by saying that the welfare of children is the primary consideration, and I don't think anybody has any great difficulty with that. But clinical interest of children is narrower than welfare.
I'm going to pin my colours to this mast.
Right. Can I then just push you a little bit further? In speaking of the clinical interest of children, are you limiting yourself to their physical health, or would you accept that their mental health is part of their clinical interest?
Oh, I will certainly accept that proposition.
That their mental health is
Absolutely.
part of it, right?
I would accept that, and I know where your lordship is going with that, in the sense that the educational disruption can be very debilitating for children. But you have to, I suggest, look at the practicalities of whether, in fact, there really is going to be educational disruption, and you have to ally that with what is underlying this policy of vaccination. If, for example, can you just, on this proposition, the documents there speaks, if children, one, are already largely self-immunised because they've had the infection. Two, that the evidence is there that there is no greater likelihood of transmission unimmunised than with immunisation. It's becoming more and more clear that the viral load is pretty much the same whether people are vaccinated or not. And 3, that those with whom they are going to come in contact, older people, teachers, are almost certainly going to be vaccinated. So therefore, those people are protected. So the question you then have to ask is, for whose protection, for whose benefit is this vaccination being given? And if it is not for the benefit of this cohort, it cannot, as a matter of clinical ethics, be given for any third party, and I think Your Lordship agrees with that. So we come back to addressing Your Lordship's question on educational disruption, wouldn't this upset them? To which my answer is going to be vaccination isn't the answer. Because if you can still be infected from a vaccinated individual, if you still have all the same checks and balances, masks bubbling, social distancing, that of itself is distressing for children. Question whether you really need it or not. But finally, what the Chief Medical Officer also did not take into account at all was that the what he actually concluded, and we'll look at his report in a minute, amounts to, on the cohort, and we actually check this, there's almost 4 million children at this age, it amounts to vaccinating them a loss for them of, at worst, median 1/40th of a day's loss of school. It looks remarkable, the numbers, 110,000 days loss of school, which is what his report says. That actually computes out as 1/40th of a day. But the figures that are modelled are anything from 10,000 days lost to 27 million days lost. You pick a number in between. But the figures
A 40th of a day strikes me as being a wholly artificial number. If a child has to self-isolate, that child is not going to self-isolate for a 40th of a day. That child is going to have to self-isolate for a week or two.
But Lord, it's just as artificial as saying that there are going to be on modelling between 10,000 and 27 million school days lost. It's just as artificial. It works both ways. But the other important point that, in my submission, has been left from this is the number of days that are going to be lost as a result of side effects from the vaccines. Because it isn't just we're talking about myocarditis. We're talking, and I think you will have seen, that there's lists of side effects, anything from sore arms to headaches to diarrhea to vomiting. There's a list, a panoply, and the CMO admits that that has not been taken into account. Now, if I can take what if I can, I was about to do that actually. If I can take Your Lordships to Bundle 4 at the skeleton argument. Under tab 3, I think you'll find it starts at around paragraph 27.
Yes.
And you'll see that that's been analysed. And I know Your Lordships have looked at this, but if I can just take you back to it, that the modelled scenario, which is what, at the end of the day, the decision seems to be based on, is that the mean average will be 110, which is the difference between 10 or 290, school days absent in this group. Now, I agree to Your Lordship, you know, averaging out 15 minutes of teaching, of course they don't have 15 minutes off, But what it's doing is it's putting into perhaps perspective that this isn't as dramatic a saving to justify against the known and potential risks of this vaccine, rolling out the vaccine to 12 to 15-year-olds. Bearing in mind that, and I'd like to take your lordships to the final comments of the joint committee, and I think it's important to look at their description of what they say is the magnitude of harms. And we go back to under tab 9 on the 13th of September.
Yeah.
Bundle 4.
In bundle 4.
Bundle 3.
Bundle 4. Lord. 4. And it's under tab 9, bundle 4, starts at page...
Yeah, this is the CMO's advice.
No, my lord, this is the...
I'm sorry.
This is the final report on... Oh no, I'm so sorry, you're quite right, this is the CMO's report.
What did you want? The JCVI?
Well, yeah, I want the JCVI, but before we go to that, what I want to take you to is this. Under the background, it is said that overall the committees of the opinion that benefits from vaccination are marginally greater than potential known harms, acknowledges there's considerable uncertainty regarding the magnitude of potential harms. And now we then go to the actual report.
Yeah, that's tab 7.
The one I want to. It's under bundle 7. Yeah, under tab 7. Give me. And if we look at page 37 under tab 7, we actually find that the committee is saying, as we've seen, considerable uncertainty regarding the magnitude of potential harms, the margin of benefit, and then they say based primarily on a health perspective, is considered too small to support advice on a universal programme. But that, in my submission, is the only perspective that should be applied here, a health perspective. And your lordships will say, well, what about the mental health? But then you consider whether actually you're subjecting a cohort of children to a magnitude of potential harms because, for whatever reason, the policy has been that if a child tests positive with no symptoms, the school closes, although I believe that that is now being abrogated in any event. No. Malone Jr.'s reminded me, which was the next point I was going to make, which is, whilst your lordships can say and ask me, well, do I agree that a mental health effect or psychological effect would be significant? I would agree and say yes. But I have no evidence to gainsay it. But then neither has the government produced any evidence to actually indicate there is no evidence that we have seen, and certainly no evidence produced by the Chief Medical Officer, that actually says anything about how vaccination will somehow improve the mental health, and if without it, there will be mental health consequences. There is no evidence of that. If the CMO wants to rely upon, well, there's a minimal loss, there's magnitude of potential harm, but we take the view that it would be a mental health advantage. We take the view, but based on what? This is again a paucity, a lack of data
Well,
that simply doesn't support.
if you go to tab 9, page 47, under the heading Advice, the third paragraph under that heading,
Yes,
they say the CMO's considered impact on mental health.
yes,
Then in the following paragraph they say the UK CMOs, in common with the clinical and wider public health community, consider education one of the most important drivers
yes,
of public health and mental health, and they give a reference.
yes.
So when you say there's no evidence, they are pointing you, are they not, to the source from which they say that education is one of the most important drivers of mental health.
Also, Miss Perry, if you look at page 45, it's evident that the CMOs consulted a wide range of people with professional knowledge in this field. Just look at the last paragraph on page 45.
Yes,
with
I've
the
seen
bullet
that.
points, and the following page.
Yes,
We're very grateful to them for taking considerable time and effort to consult their own colleagues in all 4 nations at short notice to get a comprehensive view of the balance of informed medical opinion and experience across the UK.
well, what has been said, and I can only attempt to repeat my submission here, is that what is being said, and I agree with you entirely, a driver of mental health, a driver of social well-being, not only, of course, is for children this age going to school, but of course, as we know, going to work can be a driver of good mental health, and being away from or unemployed or underemployed can be significantly deleterious. All I would say, however, is that these are statements not only of obvious, but there are a simple way of dealing with that is simply don't close the schools. I mean, that is the simple answer to that. You don't get to improve the mental health condition by vaccination if the vaccination doesn't actually achieve the very thing that you want it to achieve. If you can still be infected, if you can still pass on or transmit COVID-19, then you're still going, if the government policy is going to be that, have to close the schools if people test positive, because we know from the trajectory of COVID-19 and the SARS virus that people have actually transmitted and been in hospital. They've had COVID more than once. They've been infected by somebody who's been vaccinated. So it doesn't actually achieve the very thing that the CMO is seeking to achieve. What it's doing, in fact, is it's creating a situation where, in effect, we're saying, well, if you're vaccinated, that will somehow or other make it okay for the schools to stay open. The question then is why? If the viral load is the same, whether you're vaccinated or not, if in fact the children are probably, for the most part, immune because they've probably been infected, if the teachers are vaccinated, therefore they're protected from serious harm, then why are the schools closing? Why isn't the policy simply changing to say we've now moved on and vaccination is not the answer? And if it is the answer, then one must be troubled by this, because if it's the answer, then all the studies that are showing that vaccination is carrying the same load as unvaccinated infection, then one is wondering what, therefore, the point of this is, to expose this young cohort to what are, as the Joint Committee says, a potential of serious harm from the vaccines. Why expose them? At the end of the day, rationality is based on why is something being done? What is the purpose of it? What does it achieve? And our submission is nothing except exposing this young cohort to, as the Joint Committee says, serious harm.
That may be a view that you express, but the fact of the matter is it's not the view that 4 chief medical officers, 3 royal colleges, a number of other representative bodies have come to. And it's them that the government consulted. And it's on the basis of that information that the government decided. So at the moment, I'm very far from understanding how all of this comes anywhere near getting you on your feet for an appeal against a decision that this should be decided properly on the basis of evidence next week, rather than seeking, in effect, an emergency remedy today.
Well,
these are differences of opinion. That's understood. You've taken us to a body of opinion that your client doesn't happen to agree with. But I'm not understanding how this has got anything to do with the appeal that's in front of us.
Well, the issue essentially is that if one is looking for injunctive relief, there has to be, my understanding is that there has to be an arguable case, the underlying case, with a serious issue to be tried. I think we can all agree this is a serious issue to be tried. What I've sought to take this court to is evidence that shows that, I appreciate what my Lord Jackson has said in terms of the chief medical officer and who he consulted. But at the end of the day, what we've actually got is a basis of modelling from Warwick University. We have seen that he says, well, thank you very much, and I've spoken to this person, that person, and the other. But ultimately, the decision is based on this is how to keep the schools open because this is the number of lost days that can be avoided. And I come back to the irrationality of that against...
Yeah, all right. So I think what you have tried to show us is that there are serious issues to be tried.
Yes.
So we move on now to stage 2. Are damages an adequate remedy for either side? Answer no. So we move on to stage 3.
Right.
Balance of convenience.
Balance of convenience, yes. Yeah, my Lord, my learned junior has asked, and I would ask you just to give him 5 minutes on his feet just to take him to 2 documents
Lord,
that he wants to refer to.
the observation is for this reason. The point that my Lord, Lord Justice Lewison just made was in respect of the large volume of evidence from clinical experts and royal colleges as to the mental health effects of a disruption in education. The point that the claimants make is simply this, that the evidence base upon which that assumption is made is modelling from the University of Warwick, which is in tab 10 of bundle 4, and the entire basis of the conclusion that transmission and infection would be reduced by 33%, which is the basis of their figure of 110,000, is footnote 4, page 65, which says this.
Just a minute.
Page 65,
yeah.
tab 10, bundle 4. It says this. This one dose, because remember that they're only recommending one dose, this one dose Pfizer-BioNTech efficacy is based on studies exploring efficacy against the dominant B1617.2 Delta variant undertaken in the UK and Qatar. Now, I appreciate, of course, that the court is not deciding at this stage, or at least it will not be deciding ultimately, between 2 views of evidence. But the issue here is that they do not say when those studies were made, they do not say, and that's significant because vaccine efficacy is waning, as we know from a number of studies, and they do not say what those studies are. So we are completely blind, and this court is completely blind as to the basis of that conclusion. The second observation that the claimants would like your lordships and your lady to take on board, if I may, is from tab 6 in bundle 1, paragraph 91 of the Statement of Facts and Grounds, page 72
Just a minute.
and 73 onwards.
Tab 6, page,
Tab 6.
Page 72.
Page 72 and 73. And the observation the claimants make in relation to whether or not this is a serious question to try is this. The claimant, the defendant's own data, that is to say, Public Health England statement of the 6th of August. I can take your lordships and your lady to it if you wish, but it's tab 17, bundle 2. All of the references are to bundle 2, which is the documents bundle, page 222, found that, and I quote, from the government's own evidence, this means that whilst vaccination may reduce an individu's overall risk
Where
of becoming infected.
are you reading from?
Paragraph 92, I'm so sorry.
92, yeah.
Paragraph 92B, page 72, in italics, which is a quotation from Public Health England. So it's the defendant's evidence, not ours. This means that whilst vaccination may reduce an individual's overall risk of becoming infected, once they are infected, there is a limited difference in infectiousness. That's stage 1. An infected person, therefore, now is just as likely to transmit as a non-infected person, according to the government's own data. 2, the risk of infection, which is different. The risk of infection is different because, of course, the government may respond and say, well, fewer people will be infected and therefore there's less risk of transmission. In response to that, what we have done is looked at
Sorry,
paragraph,
I'm
subparagraph
not sure
E.
that I entirely follow this.
Yes.
92B
Yes.
says that while vaccination may reduce an individual's overall risk of becoming infected, once they are infected, there is a limited difference in infectiousness. But if they don't become infected,
Indeed.
because they're vaccinated,
And that's my next point.
right?
So the first point is, if infected, the risk of transmission is the same. Government's own data. Delta, incidentally, it's in the same paper.
Same as what?
Since as a non-vaccinated person.
Uh,
So the viral load of a person who contracts SARS-CoV-2, not COVID-19, that's the disease, serious disease, SARS-CoV-2, the viral load of that person is the same, more or less, or a limited difference in infectiousness, whether or not that person previously has been vaccinated or not.
Right.
That's the point that the PHE survey of the Delta variant, which has been 99% of the incidence of SARS-CoV-2 since June, references the same document.
Yeah.
That's what that says. 2, your lordship's point, which I hadn't forgotten about, is what is the risk, relative risk, of being infected for a vaccinated person against a non-vaccinated person, and that can be deduced from an analysis of the evidence, the PHE surveillance data, which is set out at page 74 of bundle 1, subparagraph E. And I quote, of significance and in relation to the most up-to-date data, that is to say August, about the transmission of the Delta variant in England, August at the date of which the statement of grounds were submitted, of course, the most recent PHE surveillance data and data about vaccine uptake reveals that 53% of those under 50 years old who have had one or both doses of the vaccines have been infected since the 3rd of August 2021, while only 47% of that age group have had at least one dose of the vaccine. That suggests, at least, that vaccination, in addition to not reducing the risk of transmission, does not reduce the risk of infection. This can be established by the following data, all Public Health England. And then there's an analysis of the data which is there hasn't been challenged by government in their statement of facts and grounds, and therefore one must assume, for the purposes of this exercise, as to whether there's a serious issue to be tried as true. If that's the case, you have on the one hand government data saying no difference in transmission, no difference in infectiousness. On the other hand, the government saying we have one study in Qatar and maybe a study in the UK. We don't tell you what it is. We don't tell you the date. We don't tell you the relevance of that study. That is the entire basis of that 33% efficacy that is absolutely at the heart of that Warwick University data. So even if 110,000 school days in 6 months, which equates to a 1/40th of a school day on average, even if that is good enough for your lordships, it is based only on that. And that's the serious issue to be tried, Lords.
Can I just... There was one other document, and it's at volume 4 and at page 93, and I think this is the final document before I go to the other matters, which I'll do very quickly. This is a document that emanates from the University of California. It's dated August 30th, 2021, and I'll take you straight to page 93. Oh no, page 94. As of last week, August 2021, hospitalisation rates for children aged 12 to 17 continue to approximate the moderate rate shown in figure 6.
Sorry, where are you?
Sorry,
On page 94?
93, my lord. Halfway down.
Yes.
Middle, yes. And then if you read that, about the rate remaining consistent, given the nearly 5-fold disparity in risk of hospitalisation for adolescents with and without comorbidities, it's important that the benefits of vaccination be clearly weighed and conveyed in the context of unique health risks of the individual household. So all of this is being taken on board in America. The benefits of vaccination in previously infected children should be further studied and a harm-benefit analysis performed. A history of SARS-CoV-2 infection may be found to provide similar or superior immunity to vaccination, and a recent study found a 4-fold increased risk of post-vaccination myocarditis in those who'd previously been infected with SARS-CoV-2. So that's another danger they're exposed to. If we turn over the page, this report tells us at the top that in the light of the vaccine-associated cardiac harms described in this report, further research as well as transparency about possible vaccine-related harms in relation to an individual child's COVID-19 risks is indicated. Alternate vaccination types, dosing or strategies, such as those that take a history of infection into consideration, may eventually be found more appropriate in this age group. And then our report, the final conclusion, is our report on post-vaccination CAE, that's cardiac adverse event, rates following dose 2 of 162.2 and 94 per million for boys 12 to 15 and 16 to 17 respectively. I'm not going to go on except to say to your lordship...
Well, isn't it quite important to go on?
Well, yes.
Because they're not saying that the United Kingdom's decision to offer one dose is bonkers. They're saying that's a possibility. That's one of their suggested courses of action.
Well, it is, but they also say, as is seen in Europe and every other study, that they're effectively saying further research needs to be done. There may be other courses they've got to be looked at, but importantly, transparency about possible vaccine-related harms has to be absolutely clear. And we are dealing... Can I move straight into then the question of balance of convenience, which is what we in fact invite me to do. When you are looking at, from what my learned junior said to you, what the basis of the decision, and you're looking at what the Joint Committee has said, and you know we've seen further what Europe has said, what the Americans are saying, that further data is required, further research is required. question has to be asked on the balance of convenience. What harms will it do to stop the vaccines now? What harms will it do to allow the vaccines to continue? What is the balance of risk? And we would submit, my lord, to this court, my lords, my lady, that there is absolutely no harm at all in stopping the vaccines, stopping the programme, for the reasons that has been pointed out. And there is every good reason to stop it, because it might avoid the potential magnitude of harms that have been flagged up. You may find on the desk in front of you that in fact only today Brazil has suspended its vaccination
Sorry,
program.
only today?
Only today Brazil has suspended its vaccination program because of the death. They're looking into the death of a beautiful 16-year-old 3 weeks after she was vaccinated from heart failure. The point is that this is a moving ground, and because it's moving, there are many arguments that have been made in respect of vaccination, about vaccination healthy children, and we know all those arguments: smallpox, polio, diphtheria, they're all out there. These are tried and tested. These are vaccines that have gone through all the very strict rigour of testing. The point about this vaccine is that it is brand new. It's gene therapy vaccine. And that's why even Pfizer's own trials won't be completed till 2024. There is a trial apparently going on which is scheduled to deal with this cohort in about 6 to 8 weeks from now. Why, one asks, should one not be waiting for the results of that trial from Pfizer to see what that data is, rather than if you can show no benefit but there is potential harm, you have a rollout because it's been planned and it's been put into place even before, we suggest, the government had the data to implement it. But the question for this court is, in terms of the argument, what is the balance of convenience? Well, the balance of convenience is we hope, shown the court that children not at risk of not getting the vaccine, but they could be very serious risk of getting the vaccine, and that's really where the balance of convenience lies. Oh, bundle one, yes. I'm not going to take you there, Lord, but I'm just referring your lordships to bundle one, page 76, which is the originally called the core bundle, and that is in fact the statement of Mr. Jackson, my instructing solicitor, which actually, which is,
This is about risk of harm.
it is
Yeah.
the risk of harm.
And it's from the Pfizer study.
Yeah. My lord, the important thing, of course, to remember there is that comes from the Pfizer study, of course. That comes directly from Pfizer.
Yeah.
Where was it? Right. So I've dealt with, I think, the balance of convenience and what we wanted. I wanted now to, conscious of the time. My learned friend, he's correct, has flagged up that the original the original authorisation for the injections for the 16-year-olds above was given in December 2020. That's absolutely correct. They were lumped in with the rest of the...
Are we moving to what you earlier described as technical matters?
We have, yes. Did your lordship want me to...
No, I just wanted to situate myself in where we got to, right? So that you're dealing with the
I'm dealing now with...
point of delay.
And I'm dealing with this because I have to address this, because I have to say to your lordships the following.
But just a minute. Your immediate goal is to stop the vaccination programme.
It is.
And if I've understood it correctly, you want to stop it not only for the 12 to 15-year-olds, but also for the 16 and 17-year-olds. Although 12 to 15 is at the forefront of your skeleton argument, but I think you want to stop both.
I would like to stop both.
Yeah.
The problem is that I think...
So you don't need to attack the authorisations to stop the vaccine programmes.
Correct. And that's why we have produced, but not counted up yet, an amended statement of facts and grounds and an amended judicial...
So do we need to worry about this?
No. No. You don't need to worry about it more than hopefully I don't.
Mr. West makes the point authorisation and administration are two quite different things.
Quite.
Seems to be right.
He is.
So the vaccines can be perfectly legitimately authorised, but not yet administered.
Absolutely.
And what you want to stop is the administration.
We do.
So I think we can park that, can't we?
We can, and I'm very happy to park that. And therefore, all I then move to is just to say to your lordships that in fact, in recognition of that particular situation, we have actually done an amendment to our judicial review claim.
Oh, have you?
Which directly, but your lordships don't need to be troubled with that now, because obviously you've heard all the arguments anyway.
Yeah.
All it does is that it addresses the very point that Mr. West, my own friend, has raised, which is quite rightly
And
so.
in this amendment, which I assume you will be asking the administrative court to authorise, are you attacking the advice of the chief medical officers? Because they're not in the claim at the moment.
No, because of course, my lord, the Secretary of State, we did actually raise this with the department, the government legal department, and we actually, they advised us that the proper defendant was Secretary of State, because at the time the advice was coming.
No, I follow, but it's that advice is not yet challenged in these proceedings.
No, but it will be.
Yeah.
It will be. Yeah. And again, we didn't even bring in the chief medical officers and nurse department.
No, I'm not suggesting that they should be parties personally.
And Jackie, we undertook to amend in the skeleton argument
Yes,
the interim injunction.
yes. Melanie, I don't think it's just a technical point. We've undertaken to do the amendment in the skeleton argument, and we have in fact prepared it, so it is available for anybody to see. I don't think I can assist the court any further unless there's any point that any of the lordships.
Thank you very much, Ms.
I'm very grateful. Thank you.
Yes, Mr. West.
My lords, my lady. It's important to the outset not to lose sight of the fact that this is an appeal against a case management decision. My learned friend at the outset referred to technical matters and referred to the practice direction, 52, paragraph 4. This is a case management decision against which the appeal lies. And the claims...
Yes and no.
But
The effect of the case management decision was that no injunction was granted.
Indeed, my lord. But it's also important to be absolutely clear what is the nature of the injunctive relief which is being sought.
Yeah.
Because if one turns to the application notice, and maybe we should actually do this. I'm taking this from the core bundle for the Court of Appeal,
Yes.
which is
Hi.
tab.
Tab 3 is the injunction they want.
Yeah.
I think it's tab 5. I think it's bundle 5. Sorry.
Yes, it is. I just said.
No, I had the right one.
Sorry, where am I supposed to be? Here in bundle 5?
Bundle 1, tab 1.
Sorry, it's tab 1 in the core bundle. It's the. If we look at what is being asked
So
there.
it's the core bundle, not the.
Yes.
The appellant's, you're looking at the appellant's notice, are you?
Yes, the appellant's notice.
Yeah.
if your lordship or ladyship turn to the appellant's notice, it's page 5. Box 5, section 5, is asking for the court to grant the interim relief sought in the High Court pending the hearing in the Administrative Court on the 28th of September 2021.
Yeah.
If you then turn over 2 pages, section 9, what is the appeal court to do? That box says something different. Grant the interim relief set out in the attached draft order pending either the determination of the claim for judicial review or fuller consideration of the application for interim relief in the Administrative Court on the 28th of September 2021. And those are clearly 2 quite different applications, in my respectful submission, with quite different consequences. Both intrusive, but one clearly more intrusive than the other. I understood from your lordship's indication at the outset of the hearing and the way in which you addressed my learned friend that what you were considering was the question of whether there should be emergency injunctive relief up to the 28th of September. And that is what I propose to address you on primarily. But if you feel I should go further than that, I'm very happy to do so. But my understanding is you're looking at an injunction which would take place from now to the 28th, pending the substantive hearing in the High Court. Clearly, if that were not to be the case...
No, can I concede that, my friend? I don't understand quite what that clearly is not in the application.
So you're asking for an injunction to last for the next 6 days?
6 or 7 days. So no,
I'm very grateful to my learned friend for that indication. Because, as your lordship or ladyship will be aware, producing evidence on the long-term impact of a suspension of the programme is not a straightforward task. It involves a number of agencies. It's not just the Secretary of State as defendant, as it were, as the policy holder. There's the MHRA, the JCVI, the actual administration on the ground, which is done through NHS England. These all have to feed into the evidence that needs to be before the court. And clearly there's a practical limit as to how quickly that can be done.
Not quite sure why the MHRA need to be involved.
Well, because the original order was to suspend authorisation.
No, I follow that, but I think Ms Perry's rather backed off.
But she's
that.
back, yes,
She wants to stop the administration of the vaccine.
But even so, we're working hard to produce evidence by Friday, which is the deadline that the judge has set. And I can come on in due course to deal with the short-term impact. It's obviously important to start with the nature of the substantive challenge here, because you've been addressed on that today. Now, in fact, there are 5 decisions in the Statement of Facts and Grounds. 3 of them are what I would call authorisation decisions, and I think we've established, it doesn't appear to be, that the authorisation challenges are being maintained. Those are challenges to the Pfizer vaccine for, first of all, 16 to 17-year-olds, that was in December, for 12 to 15-year-olds in June, and the Moderna vaccine for the whole cohort up to 12 to 18, which was in August.
Well, I'm not sure. They're not being maintained on this application. I'm not sure they've been abandoned in the underlying proceedings.
Well, that point is taken. But of course, in that regard, it's important to make clear that the challenge on the current application is against the use of what I call the Regulation 174 procedure. That's effectively the emergency authorisation. That was used for the Pfizer vaccine for decisions 1 and 2.
Yeah.
But
it wasn't used for Moderna.
It wasn't used for Moderna, and it's not now used for Pfizer. Pfizer, there's the other procedure.
You've made those points in your...
Yeah, so I just repeat it. So there's an academic element to that challenge anyway. And the decision of the JCVI in July, of course, has been overtaken by the decision in August. So we say that decision becomes academic. And in fact, what this challenge is to the decision in August that 16 and 17-year-olds should have the vaccine administered. And that programme has started on the 5th of August and is rolling forward. Been going now for a number of weeks. and it's the challenge to the administration of the vaccine to the 12 to 15-year cohort. And as my learned friend has explained, there is, as matters stand, there is no challenge on the papers here. So it's a challenge being made by way of amendment. And obviously we haven't even seen that challenge, therefore can't address it or see what terms it's in. So I just make those points up front, because you're in the unusual position where for your purposes today, a large amount of what is in the Statement of Facts and Grounds is either not being pursued, as your Lordship has said, for this application, or the matters that have been pursued are matters that actually aren't yet pleaded out in a Statement of Fact and Grounds and have not been addressed by us in our summary grounds of resistance. And we said that's a very important point to take into account. There are, however, two other points I would like to address you on at the outset. The first is my learned friend said at the outset that part of her case was that the known risks were not sufficiently disseminated. Now, that is not part of the existing claim. The known risks are not sufficiently disseminated. I accept that she is saying that the known risks are not being weighed appropriately in the balance of risk and benefit, but that is different from saying that the known risks are not being disseminated, presumably to those who will be offered the vaccine. I don't know whether that point is being addressed in her amendment, but I just need to make you aware that's not in the current. And the second point I'd like to address you on is the issue of standing, which you've already explored. Of course, we did, as your Lordships and your Ladyship may not be aware, but at the pre-action stage, the letter that was sent under the pre-action protocol did not identify the claimants. The solicitors said they were going to be identifying the claimants later. So we had no idea whether the claimants would actually have standing when they appeared. We have not taken a standing point in the summary grounds because we accept that the two children are within the cohort of those who will be offered vaccination. And it would be, I suspect, rather hard to persuade the court that did not give a sufficient element of standing. But nonetheless, it is very important for the purposes of interim relief to have regard to the fact that these are but two children out of a very large national cohort. The evidence, I can take you to it if you wish, the evidence has been filed by the litigation friend, claimant's mother, is that she does not want them to be vaccinated and they do not want to be vaccinated. She has a concern about whether there may be, I use the word loosely, coercion into vaccination, pressure to be vaccinated.
On the elder one.
Yes, on the other one. But there is no, as I think, as your Lordship said earlier, there is zero risk between now and between the 28th of September.
Well, as I understand the evidence, the mother says the younger one is not competent to decide for herself, so she will make the decision, and she's made it.
Yes.
The elder one is presumed to be competent, but she's concerned about pressure to make the wrong decision.
Indeed. But for present purposes, for the purposes of deciding whether you should grant a very draconian, very intrusive measure of interim relief, the claimants actually before you have, as I think it was said, a zero risk of being vaccinated. So therefore, in my respect for submission, that should be an end to to determining the application, because there is on one side of the coin, there simply is no risk. My learned friend has to persuade you that she is entitled on behalf of those two claimants who have no prospect of being vaccinated before the 28th of September, that the court should intrude on behalf of all other children in a way which will undoubtedly deny benefits to those who wish to obtain them, will undoubtedly deny those who wish to avail themselves of the offer of a vaccine, weighing together the risks and the benefits. My respect for submission, there is no basis for such an application.
Yeah. I mean, in effect, I imagine what you're hinting at really is that Ms. Perry's got to persuade us that she's entitled to, if you like, summary judgment on the substantive judicial review claim.
That is what it amounts to because of the nature of the intrusion. I would accept that formulation. I would accept I don't intend to address you this morning on the substance of what my learned friend has put forward in any great detail, because I think it's absolutely clear from the way in which she's taken you to documents, she's put her case, that what ultimately this comes down to is taking a different view of the evidence and where the balance should lie. It is clear, you've seen the statements of the latest statements of the JCVI and the Chief Medical Officer. It is clear that it is accepted that there is a benefit from vaccination, and one is always looking in vaccination at a global. There is a benefit, a benefit which is acknowledged to be small. It is also acknowledged that there are side effects potentially, and a decision has been made by the expert statutory committee appointed for that task that in respect of these cohorts, the balance lies in relation to 16 to 17-year-olds, that they should be offered a vaccine, and in relation to 12 to 15-year-olds, that further advice should be sought from the Chief Medical Officer as to the wider benefits, and his considered view is that the wider benefits taken into account mean that that offering the vaccine is one dose of the vaccine is appropriate. So in that regard, we say substantively that my learned friend faces an insuperable hurdle in showing to any court that the balance should have been struck in a different place. These decisions are carefully weighed, looking at vast amounts of evidence. Now, this court this morning can't go into that. My simple submission is that this is a balancing exercise that's being attacked. And the basis on which is attacked
But
is simply...
I just need to be clear. Are you asking us to approach this application on the basis that there is a serious issue to be tried?
No, because we say, for the reasons set out in our summary grounds...
I mean, if you are saying there is no serious issue to be tried, then it seems to me you've got to address the points. Well, now, you may do that shortly, but they've got to be addressed.
Well, we address them to the extent we've addressed them in our summary grounds, and we say on the basis of our summary grounds, permission should be refused. And my respectful submission is in circumstances where we're saying permission should be refused on the basis set out in our summary grounds, it must follow that there cannot be a serious issue to be tried for the purpose of injunctive relief. And in fact, that, in my respectful submission, is where it ends for us. It has to end for us because we are saying permission should be denied. Now, of course, I totally accept, my lord, I totally accept that permission being denied in relation to issues such as delay may not apply when we look to see, we don't know what's in the amendment. We don't know the amendment will be approved. So that could change the position. I accept that because I'm tilting at an unknown time.
Does that also mean that until the challenge to the September advice has been formulated, we are not in a position to say whether there is or isn't a serious issue to be tried?
Well, I think that must be the logical... We don't know how my learned friend... She's addressed you this morning, but we don't know how it is formulated as a pleading, which is why I stand here in front of you actually unable to address that, because that's not been formulated as part of the statement of facts and grounds. So, with respect, I say there is no serious issue, and it's because permission must be refused for the reasons in our summary grounds. I'm very happy to take you back through the summary grounds.
But that doesn't mean, does it, that the application for permission for judicial review must fail, not least because the challenge to the administration of the vaccine to the 12 to 15-year-olds has not yet been formulated.
That is correct. But the difficulty I have is, it's rather circular, the difficulty I have is I haven't seen that challenge set out. But my lord, I would say that if this assists the court, I would say even if there were a serious issue to be tried, that the balance of convenience overwhelmingly lies in favour of not granting injunctive relief until the matter can be properly dealt with. And that there is no underlying basis to disturb Mr. Justice Swift's order.
Yeah.
And I say that because it is a case management decision within the terms of paragraph 4.6 of Practice Direction 52A. Mr. Justice Swift has not determined any matter. He has made provision for a hearing to be held, which is a timetabling matter. He's made provision for the service of evidence. My respectful submission, that is a classic case management decision.
Well, I take up the point that my lord made when you started on this. Of course, it is by definition a case management decision to timetable a decision about something for 1 week, 2 weeks or 3 weeks into the future. But if what is objected to is taking place within that period of time, then clearly the decision to defer a decision amounts in substance to a refusal of the interim relief over the period of deferral. So I think it may be that which led my Lord to say yes and no to this being a case management decision.
I accept that, and my Lord, my strongest point is not that this is a decision with that there's a matter of construction. This falls within paragraph 4.6.
No, well, you say it's the balance of convenience overwhelmingly favours refusal at this stage.
Exactly, my Lord, exactly. So I don't think I'm required to show this as the importance of whether this is or is not technically a case management decision is actually neither here nor there. But I just make the point. I've referred to the authorities. One, of course, is your Lordship's own authority, which I cited from. But we say the important point is if one looks at
I'm not sure why that's cited. It was an application for permission to appeal, which is not usually citable, although it did get referred to in the Supreme Court for reasons which I don't understand.
Very widely,
there we are.
It's very widely cited. I always hesitate to cite judgments back to judges. But the test that's suggested there is, was there a misdirection in law? Was there a failure to take relevant factors into account, or were irrelevant factors taken into account? And was there a decision outside the generous ambit of a decision maker? Or even accepting that we're talking, if we say we're not talking about a strict case management decision, we're looking at what was effectively, I think my Lord says, is a refusal on the papers of a substantive refusal of interim relief. We don't know there's any misdirection in law, and all the relevant factors were in fact taken into account by the judge. May I invite you to turn to his order, which I don't think we've looked at this morning.
We're in bundle 5. This one.
Yes, it's what I call the core appeal bundle.
5.
It's tab 4, my Lord.
Yes, got it.
What factors did he take into account? Well, we find that at paragraph 4 on page 23, and he says they said had a strong case for refusing the application for interim relief and application for permission to apply. That, of course, is on the basis of the claim as it's currently formulated, not taking into account the proposed amendment. I accept that. I consider both these applications should be determined at a hearing. He doesn't accept the submission had to be heard by yesterday or on Monday. First, he says, there is no possibility either claimant will be required to be vaccinated in the near future, certainly not before the date set for the hearing of the applications. And it seems to me that that is a proposition which is incontestable on the evidence.
Well, I think you go further and say there's no possibility that either claimant will be required to be vaccinated at all.
Well, there's no requirement because it's not mandatory vaccination. It's the only basis on which the vaccination could ever occur on these facts and taking the witness's evidence is that if there was some element of pressure for the child who is Gilead competent to decide to change from the view that she has expressed to her parent and to depart from the expression of what her parent says. That's what the evidence would suggest. So he looked very carefully at these claimants, these two claimants. And then he says, there's no contention there's a decision in favour of mandatory vaccination. No evidence to support such a contention, which again is absolutely true. This is a voluntary process. Then he says, second, so he's looked at the claimants. The orders would be wide-ranging, affect many thousands of persons not parties to the litigation. So he's actually carefully weighed the interests of the claimants and the interests of others. So he cannot be said to have taken not to have taken relevant factors into account in terms of how the claimants relate to a wider constituency. And then he says, he then weighs the interests of the claimant and the defendant, because he says it provides for the application to come on promptly. So he's acknowledging the claimant's wish to have this matter determined promptly. But he's also recognising that the defendant has to have the proper opportunity to respond to the application and the documents provided support. So he's balanced not just the claimants and others, he's balanced the claimants and the defendants. And in my respectful submission, it will take something quite extraordinary to say that he did not properly direct himself and he did not carry out the appropriate balancing exercise. And I totally accept the claimants may not like that decision, but that doesn't make it a decision which is unlawful. And in my respectful submission, that's an end of it. And that is why we say permission to appeal should be refused. There is nothing wrong with the order. Now,
Yeah, it's not a question of whether the judge's order was lawful or not, it's whether it was wrong.
that's wrong. And it's not wrong. So, but I will deal with the substantive grounds because they are important. They do in part go to the question of whether there is anything underlying the order where the judge didn't take anything into account. And here I would just like to remind your lordships, your ladyship again of the respective roles of the individuals who we're concerned with. We have the MHRA who authorise. We have the JCVI, who are the statutory committee to advise on vaccines. We then have the Chief Medical Officer, and we have the Secretary of State. So we actually have 4 people involved who each in different ways contributed to the situation where the offer of a vaccine is being made available. If I may, I would just like to take you very briefly to one authority in the authorities bundle, which is actually the regulations which relate to vaccination and the role of the JCVI, because this is important, just so that it's tab 3. These are the Health Protection Vaccination Regulations 2009. Sorry?
Our.
Yeah, your authority, yes, your authority. So these, and if I could, if you look at Regulation 2, which is on page 14, obligation on the Secretary of State to ensure implementation of JCVI recommendations. 2.1. This regulation applies when the JCVI makes a recommendation which meets the conditions set out in paragraph 2. And then those conditions are the recommendation must, and they are matters A to E over the page. And then 3, the Secretary of State must make arrangements to ensure, as far as is reasonably practicable, that the recommendation of the JCVI is implemented. Now, in relation to the COVID vaccines, this is not, they do not engage.
Yeah, I think that's
Yes.
common ground, because they don't demonstrate cost effectiveness.
Because the vaccine programme, which, the strategic decision was taken to acquire the vaccines in advance of authorisation, you could have no meaningful cost effectiveness study in that
Yeah,
circumstance.
but the Secretary of State has said he will nonetheless.
Because the Secretary of State accords great deference to the JCVI. That is, in my respectful submission, that the provision I've taken you to is what we might regard as a statutory safeguard. If the JCVI ticks all of those boxes, then there's an onus on the obligation, there's actually a statutory obligation on the Secretary of State to implement. Outside that, the JCVI is an expert committee. It makes recommendations to the Secretary of State. The Secretary of State considers them, obviously gives some deference. The JCVI can make any sort of recommendation. And this is important because one of the grounds of challenge, which I'll address now to the judge's order, was that he didn't take account of what was said to be the irregular nature of the recommendation. My lords, my lady, there's nothing irregular about the JCVI reaching a recommendation saying, as far as health benefits are concerned directly, we don't feel we've reached the point where we can recommend, but there may be wider impacts and you should go to the Chief Medical Officer. We say there's nothing irregular about that, and there can be nothing irregular about the Chief Medical Officer performing his task of looking at those wider impacts and coming up with a balanced recommendation, which takes as its starting point the JCVI. So I just address you now because I find the suggestion there is something irregular about the process that's been followed, in my respectful submission, is hopeless as a submission. And I should also just say, as I've explained the different roles, the MHRA, the JCVI, I'm grateful to my learned friend for her withdrawal of the suggestion that the Chief Executive of the MHRA had been disingenuous. That is unfair, because it does not reflect the different roles of those two bodies, as your lordship was examining and exploring with my learned friend.
But just going back to this irregularity point, if the JCVI were performing the functions required to be performed under the regulations, one might say that they had gone beyond the remit given by the regulations. I can see that one might say that. But if they weren't acting in accordance with the regulations because they didn't go through the cost-benefit analysis, one might have thought that the Secretary of State was entitled to consult whoever he wanted to.
Indeed. Indeed.
And if he chose to consult the JCVI and asked them to give him a recommendation which went beyond their statutory remit, one would have thought that that was perfectly lawful.
Well, I think I'd agree. I'd agree. Well, I don't think it's going beyond that. I think the point I'm making is the statutory remit of the JCVI in terms of making recommendations for vaccinations is not limited to the power in those regulations. That's simply a specific power that deals, as I say, the way I characterise it is it's a statutory safeguard. So if the JCVI decides of its own motion, these are to a body of experts from a variety of different backgrounds, if it of its own motion decides that a universal vaccination programme should be offered, and it can go through those hoops, it then puts the burden on the Secretary of State who has to, as far as it's really practical, implement it. But that's a particular kind of recommendation that doesn't, so there's no suggestion that by making a different sort of recommendation, the JCVI is going beyond its statutory role and function, because it has a very wide statutory role and function, which I've summarised in the summary grounds. So that's what we say. So we say there's nothing irregular about this decision. The second point I'd like to address you on, taking it slightly out of order, is the best interest of the child. Now here, you explored that with my learned friend. In my respectful submission, of course, to say the judge did not take into account the best interest of the child begs the question of how one interprets best interests. We don't accept the submission of my learned friend that this is simply effectively looking at simply matters of what is in the clinical interests. It cannot mean that. It's the welfare of the child. It goes wider. And that wider concern has been a constant theme in the JCVI recommendations throughout. If we look at the August recommendation, if I could take you to that, this is what is called the High Court Core Bundle, which is, I think, Bundle 1. Take us to Bundle 1, page 342. Just to...
Yeah.
This is the August recommendation. This is the challenge recommendation for 16 to 17-year-olds. I'd just like to draw your attention to page 347. And this is dealing, I'm 4 paragraphs up from the bottom. A sentence begins, children and young people aged over 5 years. 347, page 347 of Bundle 1.
Yeah.
So it says, so this has been dealing with, earlier in the document, all 16 and 17-year-olds being given an offer of vaccine. Then we drop down to the paragraph I've referred you to. Children and young people aged 12 years and over who are household contacts with persons, adults or children who are immunosuppressed, should be offered 2 doses of Pfizer vaccine on the understanding the main benefits from vaccination are related to the potential for indirect protection of their household contact who is immunosuppressed. This is the wording I draw attention to. The offer of vaccination may help to alleviate stress and anxiety experienced by the children and young people living in these different circumstances. So we say that's a classic example of the JCVI having regard to the welfare in its widest sense, stress, anxiety, mental health issues. We see later, as it runs as a theme through the later September recommendation of the JCVI and the Chief Medical Officer's advice, we see reference to education. So we said the orientation for the best interests of the child in these circumstances. It's the welfare of the child. It's not just the clinical health. It's also the mental health. It's also the educational benefit. It's the wider disruption. It's in its widest sense. And the second point relative to that, my learned friend explored with you statistics about the amount of time that was lost and the 40th of a day that you explored. Of course, my lord, that is an artificial way of looking at such statistics. It's like saying that the clinical risk of something happening to you is 1 in 100. That looks like a low risk, but if you're the person on whom the risk arises, it's 100% of the risk. You don't get 1% of the risk, you get 100%. So these 40ths of a day are of course misleading, because that's not what's going to happen. What's going to happen is that actual children, individual children, are going to be denied education and are going to be disrupted. And that is where the focus should be and what one is looking at. So I say that statistic is really not very helpful, not very relevant. What's relevant for the court is to look at the impact on the individual child that arises, and there are a sufficiently large number of individual children who are going to be affected for this to be a measure that is well within the measure of discretion of decision makers. So we say when Mr. Justice Swift was looking at making the order, he was well aware of the interests of the child, because he had in front of him, it was in the bundle, he had the JCVI statements, he had the most up-to-date ones, he had the 3rd of September, he had the Chief Medical Officer's recommendation. He was very well aware, he could see that the interests of the children were taken into account. So how it can be said that he didn't take that into account? He must have taken it into account, because otherwise he could not have reached the decision that he did. So we say the suggestion of the best interests of the child have not been taken into account by the judge below, simply unsustainable. Because, ultimately, on this point, what the claimants are saying is, if there is any risk to a child, the programme should not proceed. And if you look carefully, I invite you to turn it up, Statements of Facts and Grounds, paragraph 119.2, you will see that they seem to suggest, if I read that passage correctly, that there could never indeed ever be a trial which could establish safety, because the number of children involved would be so great that you would effectively be doing a mass trial without a mass clinical trial without consent. We don't accept that as a proposition, but that is their case. Their case is there should be no vaccination. They need to come clean about that. But we say the judge was looking at the best interest of the child, the welfare of the child, mental health issues, educational issues. He was approving the offer of a vaccine to those who wanted it in circumstances where the JCVI, the MHRA, international regulators have all accepted that the benefits outweigh the risks, even if by a small margin. We say that's obviously a decision that's perfectly rational and perfectly defensible. But it's also, that balance was also very obviously in front of the judge when he made his decision. So we say it cannot be said the best interests of the child were not taken into account.
Mr. West, may I just ask you a question on that?
You do, my lady.
The legal route by which the welfare of the child, the best interests of the child, might be relevant is what? That it's a Wednesbury consideration? I mean, is there an express statutory route in this context which requires decision makers to take the best interests of the child into account, or is it simply a Wednesbury consideration?
Well, my learned friend has in her Statement of Facts and Grounds adverted to various points where she says the best interest should be taken into account. So I'm addressing it in the sense that she says.
No, but you're addressing the argument, but I'd just like to know whether you accept it is a relevant consideration, and if so, as a matter of
it would be
why?
If the Children Act were engaged, it would be a relevant consideration. It would also obviously be a Wednesbury consideration.
Well, that was
certainly.
the question I was asking you. Yeah.
It would certainly be a Wednesbury consideration.
So you accept that?
Accept, yeah. And if it were a Wednesbury consideration, we say no challenge. No, this comes nowhere near meeting a Wednesbury standard of unreasonableness, because it's so clearly looking at a balance, looking at the upsides, the downsides, and weighing them.
Yeah.
And yes, we accept there are very, very strongly held views to the contrary. But that is not sufficient to make a decision at Wednesbury unreasonable, as the court is well aware.
It doesn't fall within the Children Act.
Sorry, my lord?
It doesn't fall within the Children Act. The Children Act statutory provisions arise where the court has to determine the question of upbringing in relation to.
Well, I think there's an attempt to read I mean, it's my learned friend's case. There seems to be an attempt to read it across and also to.
No, I'm not suggesting for a moment that this affects the substance of the discussion. It's simply that I'm not sure that there is any statutory underpinning of this, but it's clearly for a decision that affects children, as my lady indicates. It would be obvious that the welfare of the children must be a primary consideration for the decision maker.
Well, I'm not sure about that. It's clearly a relevant consideration, but what my question was designed to elicit is whether there is any relevant statutory provision which requires decision makers to take it into account as a primary consideration or to give it any particular weight. And I think from your...
Not that I'm aware of.
The answer I gather from you
Correct
is
me.
no, there isn't a relevant statutory provision which gives it any primacy, so it's a relevant consideration for a public law decision maker.
Yes.
All right.
Thank you, my lady. That's very great. But as I say, it's the central allegation is of my learned friend that this has not been taken into account. And I should say we just totally reject that as a proposition, both as a proposition of law and as a proposition of common sense and fact. It's clear, we say it's absolutely striking on the documents and on the decisions at the welfare of the child. That's why the decisions have been balanced. That's why they've developed over time, as indeed they have for adults for that matter, deciding when to vaccinate, how to vaccinate, what length of time to have between vaccinations. These have all been very carefully considered matters looking at the welfare of the individual. I've dealt with irregularity. Urgency. Well, I mean, the point about urgency is, I mean, I think my learned friend has conceded the stable door may have bolted on the 16 to 17-year-olds, but that programme has been going on for a number of weeks. And if it were now the case that today you were to impose interim relief, unless you carved out the 16 to 17-year-olds, you would have an extremely disruptive effect.
The 16 to 17-year-old programme has started and is continuing.
And is continuing.
So it would mean that, effectively arbitrarily stopping it in the middle of the presentation of a particular cohort.
Exactly, my lord. And the 12 to 15-year-old has started. Just.
That was this week.
That was this week. Just. But as I will come on to address you, these things can't be stopped. It's not like turning on and off a tap, as I'm sure one can well imagine. So I think I've addressed you sufficiently on urgency. I mean, certainly in relation to the matters which I think are not being pursued, like the authorisations back anyway. But we would still say that the decision on the 16 to... It's characteristic. The decision on the 16 to 17-year-olds was taken at the beginning of August, but this judicial review wasn't started until the beginning of September. So it's relevant that the urgency that is now claimed is not an urgency that was apparent before. And we apparently have an amendment to deal with issues that decisions took place in the middle of September, that took place at the beginning of September and on the 13th. Now, I appreciate, of course, the judicial review time limits, but there is a requirement to act promptly, and what promptness demands depends on the facts. We would say it demands acting faster than the claimants have, and we think that's a relevant consideration. The final point I wanted to address, so they say the urgency that's necessary. We don't accept there's necessary urgency for this injunctive relief. Their final point was they said that because the judge had given weight, I think, to the fact it was a voluntary vaccination, that could mean there could never be a challenge to the authorisation of a medicine. I mean, we simply don't see how that final ground is meant to work. There's no suggestion that you cannot challenge an authorisation, whether it's voluntary or compulsory. The authorisation can be challenged qua authorisation under any circumstance. In fact, I think what this morning is indicated is the challenge for present purposes today is a challenge to administration. So I don't think that point actually takes me to it. So I come now then to the question of whether injunctive relief should be granted. We've already explored the serious issue. Let me concede for this purpose, at this point, there is a serious issue to be tried, and I have to move to balance of convenience. We obviously accept damages. There's no question of damages. I've already addressed you on delay. Delay is a relevant factor in obtaining injunctive relief, we say. But the important point is going to be the impact of a delay. Now, I am very well aware, my lords, my lady, I'm addressing you on impact in circumstances where we have not yet served evidence. So I'm necessarily having to... What I want to do is to give you some headlines on instruction, if that is going to be satisfactory. So I can't otherwise really deal with the impact. But if you wanted a witness statement which summarised this with a statement of truth on it, I'm sure we could arrange that very rapidly after the hearing, if that would make you...
Well, that's part of your point, though, isn't it?
Exactly. We've had no time to do it.
Quite.
We've had no time to do it. But I don't want you to think... All I think I need to try to persuade the court of this morning is this is not like turning off a tap. So we can turn the tap off, we can wait till next week, and we can turn the tap back on again. And if I just tell you in headline terms, I mean, the reason for this is that, as you can imagine, there's a logistical effort. The logistical effort gears up has to gear up before you start vaccinating. So you have to start getting the supplies in place. You have to start getting people in place to administer it. The route for authorisation is not entirely, but in very large measure, what is known as the school-age immunisation service, who go around doing routine vaccines like PAPS and flu and so on. Obviously, dealing with young people, you have a particular issue in terms of having appropriate individuals who can do it because of the age of the children. You have to gear up with people. You have to gear up with stock. The stock has to be released. Once the stock has been released, it can't be taken back. So the problems that exist in relation to stopping, obviously they're more severe the longer you go on. But even for a few days, you're having to stop people who'll be working. You're having to stop a program which has it's a carefully planned program. You can't just stop and then start again in 5 days' time. It's not as straightforward as that. So there'll be an impact on the whole program, not just on the children who would be expected to be vaccinated in the next few days. There'll be a knock-on effect. At the moment, I'm told there are hundreds of schools are going to be visited in the first week of the programme. So those schools would stop. That gives you some measure of the impact. So there'll then need to be a rescheduling exercise to make up for that. There will, of course, have been preparations made in the schools to deal with this, because a school vaccination team coming in is obviously somewhat intrusive into the school day.
I mean,
so
is the reality of it that if the thing was stopped for a week, then all the schools that are geared up to do it now would have to either be filtered in at some other stage or go to the end of the programme, and it would have to be done in that sort of way, with the impact that those parents and children at those schools who were wishing for the vaccinations to be given would lose that opportunity.
My Lord, you've put it more eloquent than I could. That's exactly the issue in a nutshell. Plus, of course, there's a cost associated with this, because people have had to be taken on to do this, and that if they're not working, that's lost. So that may be for a few days, maybe a relatively small impact, but there is actually a financial impact as well. So we say, for those reasons, the balance of convenience overwhelmingly lies in favour of there being no emergency injunctive relief, that the hearing should come on next week on the 28th, by which time we will have the ability to properly serve evidence that will enable the judge's order to be effected as he intended.
Can I just ask you about one matter, which was going back to the point about the extent to which it's possible or appropriate for the question of arguable case to be considered as part of this. Is there some distinction to be drawn between the two individual claimants for whom it's easily possible for the court to form a view about balance of convenience?
Yes.
And the, as it were, thousands that lie behind?
Yes.
Is it any more necessary for the court to consider the matter of the underlying merits of the claims in relation to them when one doesn't know exactly who they are and what their perspective is, or can they equally be dealt with under a balance of convenience analysis?
Well, we would say they could equally be dealt with under the balance of convenience. These are the claimants who chose to bring the claim. There's no, and we said that, as I said at the outset, we accept they must have standing because they're of the age cohort that's being offered the vaccine, but they are not directly affected by. Certainly for a matter of interim relief between now and Tuesday, they are certainly not affected. And we say that is a very, very relevant consideration. So we say the balance of convenience can apply to not just to them, where there's zero, but also to the others. It's the appropriate way for the court to proceed. Otherwise, the court is proceeding on the assumption there are lots and lots of people out there who take the same position as the claimants do, but there's no evidence to that effect. And given the intrusive nature of the measure and the denial, we have to be clear, if the court today imposes interim relief, you are denying a benefit to people who wish to avail themselves of it. So we say the threshold for intervening, when there are two claimants to whom the interim relief can't affect, we say the threshold is insuperable for my learned friend, with respect. My lords, my lady, unless I can assist you further, those were my submissions.
Thank you very much. Yes, any reply, Ms. Perry?
Just a few points. Could I just deal first of all, if I can sort of go backwards? My Lord, Lord Justice Jackson asked about the question, and he was giving an answer to logistics.
Sorry, I didn't hear that.
Logistics.
Logistics. Thank you.
And, well, what would happen if the programme stopped? Well, there'd be this enormous upheaval, and then, of course, it'll be, as I think my Lord Lewison said, then the school might go back to queue if they stopped vaccinating. At the wish of, at the risk, not sounding excessively presumptuous, there is one logic problem in that approach, which is that if, for example, there were very serious problems arising from these vaccinations, I'm sure this court would not be saying, well, logistics has to give way to potential health risks. And I'm quite certain the court would be the first to say to my learned friend, well, it may be inconvenient for you, but we can't have children off school or having pericarditis or myocarditis as a response to this vaccination, or, as the evidence has shown, not being able to do sport because they are affected. And indeed, there are a number of problems that arise from the vaccines. I'm simply flagging up only this point, that the logistics point per se doesn't necessarily meet the objection to this interim measure. The other point I would, there are two other points I want to address. One is that my learned friend has said, well, they don't know the case they're going to meet. I would simply say that the skeleton argument that was produced in Bundle 4 sets out in fairly great detail the point about the 12 to 15-year-olds, because by then we were, of course, addressing that point, and all that in fact has happened now is, as he will find out, and I simply flag this up, that the statement of facts and grounds for the judicial review now reflects what was more in that skeleton argument. So there's nothing that's going to take anybody by surprise. What I would also, however, add is, in terms of the timing, my friend criticises that on August 4th, the rollout for the 16, 17-year-olds was done, and we took a whole month, or less than, September 1st, to come to court. The problem one's got with a case as complex as this, and to amass the material, I'm afraid, is that if you come to court, rushing into court, and say, please sir, we'd like an injunction, one would then say, but before we can give you an injunction, we need to look to see whether there's a serious case to be tried in an arguable case. So there's quite a lot, as you've seen, to sort of put together. And it took us, it is true, less than a month, but that sort of time to put it together, 16, 17-year-olds. The same cannot be said about the 12 to 15-year-olds, because we were making our application within a day of the announcement that was made, or within 2 or 3 days, because by then we had the material that could then support it. That's the only point that I'd make on that. I'd finally would like to, well, not finally, there's another point with my own friend. He raises, as your lordships have picked up, and we now know from hearing him on his feet, but we didn't before, that apparently Pfizer, the authorisation for Pfizer under Section 174 now appears to be giving way to the authorisation under the European directive, which is...
Yeah, I think he said that in his summary grounds, if I remember right.
Oh, well, he did. But may I also say, Lord, that the very first time that we were ever apprised of the fact that this authorisation was even apparent was from the loan for some grounds.
Yeah.
You're absolutely right. All I'd say is that we wrote a fairly detailed pre-action protocol letter. We had a fairly detailed response, and that the issue of Section 174 was being flagged between the parties. At no time did the respondent or the defendant ever, or the GLD ever actually say, by the way, this authorisation has been given under the European. Having said that, my lord, it will become very clear in the arguments, in due course, that actually it really, in practical terms, makes very little difference. In terms of it has to be flagged, but in terms of the effect of the where the authorisation comes, it's a matter for the Secretary of State which route he wants to take. But to all intents and purposes, the European directive carries exactly the same type of strictures or allowances as Section 174. So I don't think that really will be, that is one of, if I could call it, one of my technical points.
Yeah.
I'd finally, however, also say to your Lordship, in terms of the issue of standing, and this is something that does need to be considered, one is dealing, of course, with two individual claimants, and one of your Lordships, or Mulaney may have said, I think it was one of your Lordships, talked about whether they could be as distinct from the thousands that lie behind the claim. The answer that we would say is that these two claimants have standing to challenge the rationality of the decision and represent a whole cohort of children out there. The essence of this is this, that if, on consideration of all the evidence, a court were to be satisfied that the vaccine, frankly, should not have been either authorised, certainly not rolled out, because it presents more dangers than it provides benefits, and therefore it's not a rational decision to go ahead and deal with this, then, my lord, it would be entirely proper for these two claimants to then be the spokespeople for the thousands behind them, as they are today.
Yeah.
That is really what Secretary says about that. I'm just going to check with Julia, who I'm sure will have something to say.
Thank you. Well, we'll rise now and just see where we've got to.
I'm very good. Sorry, Mel, is your Lordship then, are we going to wait in court?
If you wouldn't mind.
I knew that point, so I said, the end of that. Didn't you know that? I mean, who cares what the restrictions are? Yeah, you don't. Well, I did know that. I mean, I did
I know.
This is an application for permission to appeal against an order made by Mr. Justice Swift on the 17th of September 2021. It arises in the course of a claim for permission to apply for judicial review of a number of different decisions relating to the authorisation and administration of vaccinations for young people against COVID-19. The judicial review claim form was issued on the 1st of September. Accompanying the claim form was a claim for an immediate injunction by way of interim remedy. That is what is sought this morning, although the scope of the injunction has slightly narrowed. In effect, what the claimants wish to do is to halt, with immediate effect, the national programme for the vaccination of 12 to 18-year-olds. Mr. Justice Swift refused to grant that interim relief on the 17th of September. Instead, he ordered an early hearing, both of the claim for interim relief and also the application for permission to apply for judicial review. I must stress at the outset that what is in issue is not simply the grant of interim relief, but the grant of emergency interim relief at a time when the Defendant Secretary of State for Health and Social Care has not had the opportunity to put in any evidence explaining his position or all the potential effects of the grant of the interim relief sought. I should also make it clear that the Secretary of State does not accept that there is an arguable case which would warrant the grant of permission to apply for judicial review. It is also the case that one of the decisions which the claimants wish to challenge is the decision by the Secretary of State to accept the advice of the Joint Committee on Vaccination and Immunisation and the advice of the Chief Medical Officers, both of which post-date the issue of the claim form and would need to be the subject of an amendment in due course, subject, of course, to obtaining the permission of the Administrative Court. We do not need to decide whether there is or is not a serious issue to be tried. I will assume in the claimant's favour that there is. The claimants themselves are two young persons represented by their litigation friend, who is their mother. Their mother explains that she does not wish her children to be vaccinated. One of them is said to be not competent to make that decision for herself, so her mother will make it for her. The other is said to be competent to make the decision. She has, however, decided not to be vaccinated, but her mother fears there may be pressure placed upon her to accept the vaccination. The Chief Medical Officers, however, have made it clear that all choices are to be respected, whether they are a choice in favour of having the vaccination or a choice to refuse it. The question whether we should grant interim relief is determined in accordance with the principles set out by the House of Lords in American Cyanamid against Ethicon, 1975 appeal cases 396. The first question to ask is whether there is a serious issue to be tried. As I've said, I will assume in favour of the claimants that there is, but without expressing a view one way or the other. The next question is whether damages would be an adequate remedy for either party. That does not arise in this kind of case. So the third question is, where does the balance of convenience lie? It is plain, in my judgment, that the balance of convenience lies in favour of refusing the interim relief sought at this stage. First, there is no danger of any irreparable harm coming to these two children by reason of the refusal of relief. They may simply refuse to be vaccinated and their choice will be respected. Second, there are thousands at least of other children whose vaccination would be disrupted. They are willing to be vaccinated and indeed wish to be. Third, there are the logistical and practical implications of halting a programme which is already in train, and indeed in the case of the 16 and 17-year-olds has been ongoing for over a month. Finally, there is the injustice to the Secretary of State in granting an immediate injunction suspending the programme without even giving him an opportunity to put in evidence. As I have said, Mr. Justice Swift has ordered a hearing of the application for interim relief on the 28th of September. Even that is a short timescale for the lodging of evidence in a case of this nature. In my judgment, not only was Mr. Justice Swift entitled to refuse the application for an immediate halt to the vaccination programme, he was right to do so. I would therefore refuse permission to appeal.
I agree.
I also agree.
My Lord, in the circumstance, I would seek an order for our costs of attending today.
My Lord, I'm sorry, I wasn't suggesting by any delay. I can't obviously oppose it. It was the question, obviously, of normally whether there's a summary assessment, I believe.
Well, I don't think that we've been given a cost schedule.
No, and we've asked that the matter be actually for some form of assessment.
Well, Jackie, I was just wondering, would it be better for us to use the summary assessment on a different date, perhaps? Detailed assessment.
Well, yeah, or Melange is suggesting that we put off for a summary assessment at a later date, perhaps next week.
I was simply going to suggest assessed if not agreed.
Assessment,
Yes.
not agreed? Yes, I'm perfect.
Yes, all right. Well, although it's not the usual practice to award respondents their costs of an unsuccessful application for permission to appeal, I did direct that the appeal would follow if permission was granted. So I take the view that the respondents were entitled to appear. The principle of a cost order is not opposed, and it seems to me to be eminently sensible to say that the costs are to be assessed hereafter, if not agreed.
I'm very grateful. There is one other point that I just flagged to mention,
Yes.
just as a point of interest, to see whether it has any traction in this court. Next week, this matter is going back for the issue of the serious case
Yes.
of the tribe, whether it is. It's just a question of, because of the importance and perhaps the significance of the arguments, we wondered whether this court might, and I don't know if you can direct, but the suggestion that we have is that it be immediately heard by a divisional court rather than a first instance, and then either side appealing. I'm just trying for pragmatically flagging up and seeing what my learned friend might say about that as well, which I had no chance to speak to him about. But
I don't think it's for us to interfere with the listing arrangements in the administrative court.
very well, it was worth mentioning.
Yeah. Right, thank you both very much.
Ewan, as a matter of interest on that point, can you give some